But then when we are reading the term Constituent Assembly for the purpose of the proviso, at that time when it was enacted, it was in 1949.
But they contemplated it, Malaz. They contemplated it. Why would they add the word Constituent Assembly in 370 when it was
because
not?
Because at that time we didn't have any legislative assembly for the state of J&K.
No, correct. But you had the orders. Well, I don't understand. The flexibility at the instance of the Constituent Assembly, but this power is given to the Constituent Assembly, not to the legislature. It's not flexibility at the hands of Parliament or the legislature, because 147 says there's no flexibility there at all.
So there are two parts to it. First is whether the Parliament could have done it. That's a separate argument. But when we interpret the term Constituent Assembly for the purpose of the proviso to clause 3, can we by implication, because at the time when the Constitution was enacted, at that time there was no legislative assembly for the state of Jammu and Kashmir. Is that factually correct? Answer is yes.
Yes, of course.
So then when we interpret the term over here, can we interpret it to include the legislative assembly?
But Manas, how can you interpret a term in a constitution which says Constituent Assembly as the legislative assembly? I don't understand, Manas. Under what concept of interpretation of the constitution will you do that? There is no implied power. There is no express power. I mean, you can change any definition of any constitution.
That may not be. That will be it. Look, the term Constituent Assembly, when it is used in the proviso to clause 3, at that time there was no legislative assembly.
For the purpose of framing the constitution that the Constituent Assembly is formed. That's not, Malad. There's nothing to do with the legislature. Which is why, Malad, Keshavnand Bharti.
See, the explanation which has been enacted was afterwards, is sometimes in 1952. Explanation enacted and has been made part of part 1, clause 1, was probably in 1952, if I'm not mistaken.
It was there, Malad.
No, initially there.
It was amended later on. That's not it was there, but
it was there, it was amended
later.
Yes. Because at that time, then the legislative assembly was brought in. Council of Ministers was brought in. Because at that time, there was no council.
Governor Malas had to be.
There was no council of ministers at that time.
That was the Maharaja Malas. But that issue doesn't arise here. We're talking about Malas, a constituent assembly, the power of the constituent assembly. And there are now the Keshavan Bharti Malas, fortunately and unfortunately, sets the law.
Mr. Sibal, just as because we are not looking at it from that perspective yesterday, where was the first reference to the Constituent Assembly? Of course, the Constituent Assembly of the state finds a reference in the Constitution itself in Article 372.
Yes.
370(2). Where is the first reference to the Constituent Assembly in the documents which you read out to us yesterday prior to the Indian Constitution? I find that in the proclamation of the Maharaja.
Well, they are in the Constitution debates, Malas.
I find that there's also a reference in the proclamation of the Maharaja which you read out yesterday. The reason I'm asking is this.
I've already mentioned that in the Constituent Assembly debates. Iyengar, Malas, your Lordship will remember.
Yes.
I quoted Malas.
Yes, volume 8.
All there, Malas. Yes.
Page 117. Yeah, Mr. Gopal Swami Iyengar's.
Yes.
No, because when the Maharaja made the proclamation, when the Maharaja issued his proclamation on 5th of March 1948.
It was contemplated by the Constitution and the Constitution makers that there would be a Constituent Assembly which would come into place, which happened in 1951.
Right.
That's what happened.
What happened first was when the Maharaja made his proclamation in 1948, he spoke of a National Assembly.
Yes, absolutely.
Right? He says, my Council of Ministers shall take appropriate steps as soon as restoration of normal conditions have been completed to convene a National Assembly based upon adult suffrage. Then 5, the Constitution to be framed by the National Assembly shall provide adequate safeguards for the minorities and contain appropriate provisions guaranteeing for the freedom of conscience. Right. Now, what appears to have happened was that before elections were held, by adult suffrage, they composed the Constituent Assembly. That's how the Constituent Assembly came into existence. Your whole argument is, of course, that what is to be done by a Constituent Assembly cannot really be done by a legislative assembly, and therefore less so by the central government assuming the character of a legislative assembly under 356. That's the what happens then if there is no Constituent Assembly?
I'm sorry, Malad?
What happens if there's no Constituent Assembly? Do you have to create a Constituent Assembly afresh?
Malad, that is precisely between 1948 consultations. Malad, your lordship will
So now what would happen? Suppose they keep aside the procedure which they followed. We're keeping that aside for a moment.
Correct.
373 postulates the Constituent Assembly has to give its recommendation on any proposal for abrogation.
Right.
Suppose the president were to move a proposal for abrogation. According to you, how would that be effectuated now, say in post-1957 India?
Let me answer that in two parts. Number one, what my lord is putting to me is in 1948, they contemplated a National Assembly.
Right.
But your lordships must remember that those were years between 1948 and 1950, especially after 1947, after the instrument accession was signed, Malad. After the instrument of accession was signed, those were transitional periods. And when the Constitution came to be framed, there was a dialogue between the state of Jammu and Kashmir, that then stood through the Maharaja, and the government of India. And both of them decided that we will put this into the Constitution, that is 370, use the term Constituent Assembly, and you will then set up a Constituent Assembly to frame the Constitution and decide what you want to do. You must understand the historical context in which this happened. This has not happened in an isolated fashion. Malad, the Parliament of India, the Constituent Assembly in India, framed a constitution which included a provision for a Constituent Assembly of Jammu and Kashmir. Malad, surely that was not an isolated act. This happened in consultation and in agreement with the then Maharaja.
And the J&K Constitution contemplates that this legislative assembly will have no role in regards to the amendment of the provisions of the Constitution relating to Article 370.
Otherwise, they would not put that phrase.
But then how would that, what sort of a
next question is, supposing there was no constituent. That's the next question.
How do we, then what constitutional mechanism would be envisaged then?
If there were no Constituent Assembly and your lordships were sitting in 5, I would have answered that question. But luckily, we have a Constituent Assembly. But I can't answer a hypothetical question as to what would happen.
How would you then put into place the constitutional machinery? Because there has to be machinery. It can't be that, because there is no Constituent Assembly, because there is no Constituent Assembly, you cannot at all deliberate on a proposal for abrogation or modification of Article 370.
Your lordship is putting to me, supposing the Maharaja refused to have a Constituent Assembly.
No, take 2019.
I'm sorry?
Take 2019.
Yes.
When the Constituent Assembly has been convened, the Constituent Assembly has drafted the Constitution.
Yes.
Therefore, its role has come to an end. There is no Constituent Assembly.
Correct.
2019. The president wishes to modify Article 370.
Yes.
Now, we've seen the process which they followed.
Yes.
What, according to you, would have been the constitutional process to...
No constitutional process, because the Constitution of Jammu and Kashmir said, in terms in 147, that no such bill can be introduced in the legislature.
Oh, by them.
By them.
I'm talking about, by them, where the Constitution as it applies to the state of Jammu and Kashmir, which is part of the law applicable in Jammu.
So, according to you, no constitutional procedure shall be initiated for abrogation of Article 370 at all.
I've been saying it's permanent. Why do you, I've been
The argument is that after 1957,
yes,
the president ceased to have any power under Article 3 of Article 3.
That was temporary between 1951 and 1957. Where do you get that power from? You see, the point is, Malads, at that time it was temporary because there was nothing in place.
After 1957, sub-Article 3 has become odious now.
Yes, no, Malads. It can happen as a political decision. The Jammu and Kashmir government and the legislature of the state unanimously did what? And they merged. That's another issue altogether.
So, Mr. Sibal, according to you, neither the assembly can do it,
yes,
nor the parliament can do it.
Yes.
What you are saying is, while other provisions of the constitution may be capable of amendment through a process envisaged for amendment,
yes,
other than, of course, if it is hit by basic structure,
correct,
this is one provision which can never be amended.
Well, and let it put it differently. But let me put it, under what power will this take place? Let's assume Malaji can do it. If my lord put the question to me, under which provision of the constitution can they do it?
Having a permanency, the whole concept is that constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically,
Then a political act can be, but there can be a political act.
And those negotiations,
Clause 1 is the answer to this. 370 Clause 1, bit by bit modifications, exceptions, applications have come. Now, if, and one important thing your lordship will note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can
modifications.
Parliament not have amended the Constitution exercising the 368 power to abrogate 370?
No.
Which means, therefore, that there is a provision of the Constitution, apropos what fell from Brother Justice Call, that according to your submission, there is a provision of the Constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note
So we are creating then a new category apart from basic structure.
No, not
that 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 Clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 Clause 3 goes and is not brought into service, 370 Clause 1 can now be used, continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the Constitution can be made applicable to Kashmir still under 370 Clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, is now, it cannot be.
371 according to 370 subclause 1 itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the Constitution applies to the state of Jammu.
Yes.
Then what remains of 370?
Nothing.
then the only,
To say that you can,
It can
in
be
a
taken-
sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So I'm
1.
saying therefore said that
Yes.
371 according to you
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the Constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are saying
be.
that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's still-
he's arguing, but it's certainly not what I.
This is what we are saying.
Yes, Mr.
That-
Yes.
That may be his
The
interpretation.
expression.
I think, Mr. Let Mr. Sibal come, because, otherwise that will, I think, Mr. Shankar, what will happen is, we are following a certain line and a link and a syntax, so, I mean, I think, we might be broken up in the nuance of.
Because, respect Mr. Sibal, he knows the law. He also therefore didn't jump and answer the questions.
I don't think.
See, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi
can.
said, no, this is not what I'm saying something different. So we'll have to see where the call, right?
You can
I
say
understand. So
something
your
different. There's no
argument I've
issue at all.
understood at your own turn. He says that you can keep the shell, but the process is 370 and
There is another interpretation.
The problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.